All right, welcome everybody to Legal Tech Week Live for July 17th, 2020. This is Bob Ambrogi of Law Sites blog, and we have our ever-growing panel of legal tech journalists here to talk about the week's top stories. Quite a few things we want to get to today, but let's begin by introducing today's panelists. To my left, as I look at my screen, is Nikki Black. Nikki, how are you today?
Good. Good to see you all. My name is Nikki Black. I am the legal technology evangelist with MyCase Law Practice Management Software, cloud-based, so it's great for remote work if you are working remotely. I am a legal technology journalist, like everyone else here. In terms of that, I write for ABA Journal, Above the Law, Daily Record, the MyCase blog, and other publications. And I'm looking forward to today.
And thank you to MyCase for sponsoring today's episode. Victor, how about you?
Thanks, Bob. My name is Victor Lee. I'm an assistant managing editor with the ABA Journal. I handle the business of law section, which encompasses technology. And, my standard disclaimer is that the views expressed are my own and not those of the ABA or the ABA Journal or Major League Baseball. So.
Whatever that is. Joe?
Yeah, Joe Patrice. I'm from Above the Law. What I do right now is make bar exam officials mad at me. That's apparently all I do. That's been the whole week.
Well, they've got to be mad at somebody because everybody else in the world is mad at them. So.
Yeah, no, I'm making a lot of friends among the applicants, but the officials aren't happy.
Yeah. Zach Warren, why don't you introduce yourself?
Hey there, everybody. My name is Zach Warren. I'm the editor-in-chief of ALM's Legal Tech News. And start of the MLB season is actually a week from today. So there's baseball coming back. You got to remember what the MLB is.
Yeah. And robotic cheerleaders as well. Caroline Hill, it's been a long time since we've talked.
We like to chat daily now, don't we, Bob?
I know, it seems that way.
Yeah, thanks, Bob. Caroline Hill, Editor-in-Chief of Legal IT Insider publication, global legal tech publication. I write just for Legal IT Insider, and my views represent Legal IT Insider.
Yeah. And Victoria Hudgens.
Hi, my name is Victoria Hutchins. I'm a reporter at Legal Tech News, where I cover cybersecurity, technology, either regulations or how it's impacting the practice of law, and also legal tech, that sector, and delivering legal services.
And last but not least, Molly McDonough.
Hi, Molly McDonough. I'm a legal affairs journalist and media strategist based in the Chicago area.
Yeah. In my reference to Caroline and I were on a panel yesterday, sort of like this panel, only it was a group of international publications and journalists who are covering legal tech. It was kind of interesting. A lot of people I'd never met before, or even, frankly, heard of some of their publications before. So it was really interesting to me, and some good topics covered. And always interesting to me how universal are the things that we're all talking about and concerned with here. Just a reminder to anybody who's in our live Zoom audience here that go ahead and shoot us any questions or comments you cared to do so in the chat interface, and we hope to have you participate as well as to not just sit there and listen to us. We welcome your input. Where to start this week? Zach, I was thinking maybe you guys did a really ambitious set of articles this week.
Yeah.
Maybe you could talk about that.
Yeah, it was a lot. So what we published earlier, throughout this entire week, but it started on Monday, is a series looking at algorithms that state, local courts use to not only predict recidivism in the trial phase, but even pre-trial, looking at bail decisions, looking at when people are incarcerated, should they be released. And really what we found is it's kind of a patchwork. There's no standardization across the US whatsoever, not only by states, but even in a lot of cases by counties. So there's a lot of different articles that touched on a lot of different things. What these tools are, two of the most prevalent ones, you may have heard about a Wisconsin Supreme Court case a few years ago. Compass is the name of the solution. It's kind of an AI-oriented black box that has a proprietary algorithm, spits out numbers based on a number of risk factors. Some of the other ones most of the other ones are a lot more transparent. Another big one is ORAS, which is actually developed by the University of Cincinnati. The Ohio Risk Assessment Survey, I believe, is what that stands for. A few states have adopted that. And then there's a lot of variability in, once they have the tools, how judges actually apply them as well. Some judges take everything at face value and say, this is what the tool spit out, so this is what we're going to rule. A lot of them aren't taking into account what the state and local courts have for the risk assessment surveys at all, saying, we don't really trust this. We don't think it's worthwhile. So it's here, but we're just going to kind of put it to the side. And then a lot of people think that in a lot of cases, there have been lawsuits about inherent bias in these algorithms as well, and how exactly they're making these decisions, what factors come into play, the role that both race and gender play in these. So there's a lot of questions, and we tried to answer as many as we could, but there's still a lot of answers left out there. So I personally think it was cool. We spent a year on it, and I definitely think it's worth taking a look if you haven't already.
Yeah, I haven't had a chance to read it yet, read any of the articles yet. But how transparent are the courts about their use of these, and how transparent are the developers of the algorithms about those kinds of biases that might be inherent in them?
I might kick this one to Victoria, actually, because I know she did a lot of the legwork calling states and seeing what they were actually using for these tools too.
Yeah, last summer, my other editor at Legal Tech News, Reese, he assigned to all of us, we all were assigned to reach out to various states about how they're using, if they are using any risk assessment tools in their criminal justice system, and then going into details about when did you start using it, what do you use it for, the data that you guys place into the tool, how do you check the accuracy. And a lot of states, it kind of varied on how transparent they wanted to be. And sometimes it just seemed like the person I was talking to just didn't know. They were the press person for that department or the correction department. They said, I really don't know. Sometimes it did seem a little bit like they wanted to be secretive when they didn't even want to say what name of the tool they were using, but they told you, oh, we use it, or who developed it. So it was a little bit of going back and forth, a lot of that. But it was varying to kind of see. Some states were kind of like, we need to make our own because it's for people that are from our state. Other ones are just kind of like, if it's used by different states, that must mean that it's good. But it was a little concerning when you didn't hear a state saying that they checked the accuracy once they were using it. They just based it off of, oh, we saw the research and the publication about like the quality of it. And they said, okay, that must mean that it's great. It's kind of met like a standard, but there is no standard, and they don't really, some of them don't check to see like how accurate is it, the accuracy rate of recidivism, and does it help with, maybe sometimes they were looking at, does it using these assessments to see like if it helps people maybe provide better assistance in jail. And sometimes they weren't checking for that, and that was kind of concerning. But the transparency, it really varied, and it was kind of interesting. A lot when you talked about the algorithm, they just said, I don't know about it. You have to go to the provider or someone that developed it.
Yeah.
It reminds me a lot of over the years, I was off counsel to a DWI defense firm, and I was a public defender as well. And one of the issues with DWIs is trying to get access to the algorithms for the breathalyzers. And that's been this like constant battle for years between the criminal defense lawyers, and the companies. And it's the same thing here, but in a lot of ways, there's a lot more serious issues like bias that you just don't have with the DWI breathalyzers. It's just accuracy without that inherent bias. So that makes this even more concerning, I think. And quite frankly, in some ways, I'm torn because bail's supposed to be discretionary, but then again, it's really just supposed to be based upon whether someone will return. And so these algorithms seem like they would make sense and would be a great idea if that's truly what the basis is. And sometimes you want the judges to have the discretion and go with their gut feeling too, because that's what judges are there for. But then again, that doesn't always go well. So
Yeah,
You go.
Oh, definitely. And reading Reese, he talked to some experts about the topic, and a lot of people said using these types of algorithms are useful because it at least provides some consistency, and you're not just going based on a judge saying like, oh, I think just based on my experience that this person should be granted bail or they should be held prior to sentencing, prior to a trial. And it was interesting to kind of hear, I think the states that I spoke to, they always said like, we use this, we either require it or we suggest it, but at the end of the day, it's always the judge that makes the final decision. So I think that is something that I heard from states, and it's kind of interesting speaking to experts about this topic. They mentioned Pennsylvania was one of the areas that had a lot of community engagement and just kind of wanted to be a part of the risk assessment that was started in Pennsylvania. And I'm based in Philadelphia, and speaking to both sides of that risk assessment tool that was implemented this year, I spoke to people that were pro it and part of the commission and people that were against it, and they both had their opinions on it, and definitely like community engagement, and that it's, of course, the people against the risk assessment tool said they didn't want to see it enacted, but at least they said it was a little bit better because it had some community engagement.
I think that's what I would want to see in every rollout of something like this would be some kind of strong community engagement and definitely transparency in what data is being used and how it's being used, because that's where a lot of the unintentional, often by implicit and otherwise bias comes in by other assumptions that are made when developing the algorithms, and then data that is being collected in a way that creates bias in the output. I think those are my biggest concern. So the more you have kind of community engagement and the court not just saying, oh, we just adopted this and we require it, but we don't know how it works, that would scare me.
I think that is happening though, isn't it? This reminded me of an article that in Wired saying courts are, I just looked it up, so I remember reading about it. Courts are using AI to sentence criminals, that must stop now. And I haven't had a chance to read your piece, Victoria. It sounds fascinating, and I will definitely. So it was talking about the Wisconsin Loomis case, the drive-by shooting. I presume, did you reference? No doubt reference. So, and that was using Compass, the tool that you're talking about. And they gave him, just reminding myself of the fact, so they gave him a long sentence because of the high risk score that the defendant received from the black box risk assessment tool. And he challenged it, but the Supreme Court ruled against him, saying that the knowledge of the algorithm's output was a sufficient level of transparency, which sets a really, really scary precedent. Just like trusting the output rather than really fully understanding the algorithm.
Yeah. Trust the machine. That always goes
trust
wrong.
The machine. It must be right, but actually they don't seem to really fully understand.
I mean, I guess. Sorry.
Oh no, you go ahead, Victor. I was just saying I saw that.
Sorry. I mean, I guess one thing that I was kind of wondering, just with did you find that, because I mean, just kind of looking at this and what you're saying and just doing a quick read of it, I mean, just I used to work in criminal prosecution. Like what we used to do back in the days before, these advanced algorithms was they would just interview someone right before they got arraigned. They would ask them questions like, do you have a passport? What is your net worth? Where do you live? That kind of just stuff like that. And they would do like a warrant check on the person, and then they would come up with a score and then present that score to the court. And then typically it would either be, like looked at or it would be ignored. It would either be weighed, heavily or weighed not at all. And then ultimately it was really up to the judge to decide, what the bail was. So it doesn't seem like this is, on the one hand, too much different than that, but obviously because of, of the implications of the technology and whatnot, there's much more of a potential, misuse of it, or even, problems with like the underlying algorithms and whatnot. So did you get the sense that, at least for the agencies or the jurisdictions that are using this, or the law enforcement officials that are using this, did you get a sense that like they would be willing to either open it up for some kind of third party auditing or some kind of like involvement with, if not the community, some kind of third party and some independent third party to kind of make the algorithms more transparent and more easy to understand for the general public?
Yeah, I think that they would. One thing that we definitely found is Compass, the one in that Wisconsin decision, is definitely the most black box that are out there. A lot of the ones that have been developed are a little bit easier to understand, a little bit more transparent, and in particular, a lot of times are developed with local law schools. So the one that I mentioned, the Ohio one, that is all over the place, was developed by University of Cincinnati. There's another one that was developed, I believe, by University of Virginia, the VPRIA or AI or something like that, that is used, I think, by 5 or 6 different states as well. And that also gets validated by the university every so often, just to make sure that the risk factors are hand in hand with what people are actually seeing in the community. So I think a good number of them do. But what we found more than anything is, unless you are in criminal law, and especially in the general public, a lot of people just don't really have the awareness that this is something that judges have at their disposal and actually use. So a lot of people, A, don't know how to ask for it, and B, if they do, the courts will give that information, but it's not readily available. So I think that's where the push for transparency would be more than anything else. It's less getting the courts to give the information if you know that it's there, and more educating people that this is something that judges will be taking into account.
It's one more piece of information that underscores the importance of law firms and legal practitioners having technologists as part of their teams and part of their staff. I mean, I'm still reeling from the 2 or 3 year old news now from the study from Susan Neville-Omart, where she looked at the different research platforms and the different outcomes of the algorithms there. Why is my monitor is freaking out here? And she found you look at the leading legal research platforms, and I mean, everybody kind of thinks the top cases are the top cases. If you go to Lexis, if you go to West, the most important cases are going to be the same. And in fact, these different platforms, based on their different algorithms, return drastically different results. I mean, and that's nowhere near as serious as when somebody's liberty is at stake, is what we're talking about now. But it just underscores the fact that you need to have people as part of your team who can help you interpret and understand this stuff. It was actually, I wrote about it this week at Above the Law, because I was writing the AA, the American Association of Law Librarians, had their convention this week, and I kind of wrote about the importance of law librarians in that role of understanding like legal research applications and algorithms and those kinds of things. But it really goes beyond that. It's an essential part of the team. What should we move on to? Not sure what. I know, Molly, you had a couple of stories you were highlighting. Do you want to well, you can pick one.
Sure. I'll start with both are pretty timely and related to COVID. So the pandemic, but the one that kind of just shocked me this morning was the use of illegal in a Tribune story, the illegal recording of a court hearing, a bail hearing that was live streamed on YouTube. I'm still not comfortable with the word illegal recording of a live stream from a court hearing, except that you could have been there in person, but you really wouldn't have been able to record it. So, but how does that apply outside? This case involved a site that I wasn't familiar with, World Star Hip Hop, had posted the video because it was going viral, and it was a bail hearing where the defendant hadn't had a chance to talk to his public defender. Another issue with due process related to these remote hearings is that a lot of defense lawyers aren't able to connect with clients before the hearings begin, and he blurted out that he was a federal informant. So they had to shut everything down really quick, and and they asked, and the Tribune's not using the guy's name. I mean, this could really create major problems for him and his family and any of his associates. So lots of journalism ethics here, legal ethics, and court technology all wrapped up into one case.
Yeah, this was also the week in which, I think it was this week, I think I saw it on law.com, in which a hacker was able to get into stream porn into a Florida court hearing in the middle of a court hearing.
Are we sure that just isn't
probably
what Florida
livened it
courts
up
do?
a little bit?
I think that's just what Florida courts do. I'm not positive that's different.
Right. It could
Everything
just be
I've seen.
Rule 27F. It's in there somewhere in the Code of Civil Procedure. Yeah. Any comments on that?
Well, although there was another story that I read that I was going to include that I didn't, but I may write about it next week. It was a New York a decision that was issued about an issue I'd never really considered with these live court appearances, or not the court appearances, but depositions and whatnot, is coaching. And I sort of feel like someone may have alluded to that last week, but it addressed this concept of coaching a witness when they're being deposed on Zoom and stuff, when the lawyer is off camera, and ways to possibly address that. And so I thought that was interesting. There's all these different issues occurring now and being raised because this is becoming more commonplace. And it's not as simple as it sounds, just sort of this idea of let's just, put it all out on Zoom and see what happens. There's all these issues that come up that no one really thought of until you put it in practice.
Yeah.
And that's definitely one of them, someone yelling stuff out to that degree without their attorney there to say, oh, stop. No more of that. But it's interesting.
There's in Texas, Texas is partnering with Harvard's Innovation Clinic to study these first appearances too, whether it makes a difference to have a lawyer during the first appearance, which would have covered this bail hearing, to talk to them before they appear before the judge and say something that could put their entire family in peril. But yeah, so I think this is going to be a big deal, especially that's the criminal court proceedings are the ones that I've been the most concerned about going video remote only, and mostly because not that I don't think it's possible to do it with everybody agreeing, but because the way it's been implemented is that the lawyers don't have a chance to communicate with their clients in private beforehand. Even when they do have a chance to talk, there's no confidentiality. The jailers are there, others are monitoring the conversation. So there are lots of issues that need to get resolved with this before I would be comfortable with remote for criminal proceedings.
But I mean, I guess, and I mean, not having so unlike you, Molly, I am familiar with this website, and they tend to post videos of people fighting and beating each other up. And
by the way, he means the hip hop site, not the porn site that Bob was talking
well, sorry,
about.
hip hop.
Not the Florida court porn site.
There is they're kind of famous, or I guess infamous, for posting videos of people getting beat up or getting fighting and whatnot. So this seems like kind of an odd thing for them to post, but whatever. But I guess I guess I'd have to know what the specifics of this instance were. But I mean, but it doesn't seem like it's all that difficult. It's all that different from the typical situation where you have like a bunch of people in lockup, and the lawyer just goes to each one and talks to them, before they get arraigned. So I mean, on the one hand, yeah, like the fact that this person wasn't, if this person didn't get a chance to even speak to a lawyer to figure out what this person's rights were, or what this person was looking at, or what this person could and couldn't say in open court, or I guess on the Zoom hearing, that's obviously problematic. But as far as like there being absolute privacy and not, and having nobody around, I don't know if that's ever really the case, even in instances where people are, in person and there's no technology involved.
Well, I've talked before about my favorite judge these days is Scott Schlegel down in just outside of New Orleans, who's been kind of jury rigging all sorts of technological innovations using very simple software. But I know he had just emailed me, I think last week or this week, talking about how he had set up basically a virtual consultation room for lawyers and clients. It's not really virtual; it's for the clients who it's for the defendants who come in to the courthouse and the lawyer can't come in. He's created, no big deal. He's basically taken a room in the courthouse and set it aside with a computer and a Zoom and a camera in there. And he basically, a court officer brings him in there and they connect to the lawyer and the court officer leaves and they consult with their lawyer there. This isn't hard to do at all. I don't know why why the arraignment part of that. I mean, why the getting the consultation with the lawyer would be difficult. But
well, and the problem with I agree with you, Molly, about this, your concerns about having this happen in criminal cases. But the problem is that you have a constitutional right to speedy trial, so these criminal cases have to go forward quickly. And the other thing that's happening is it's a trend that I saw this week. 2 different cases where there was a prosecutor who had filed an OSHA violation because he was being required to go to work under circumstances which he felt were dangerous. And then he got COVID and was hospitalized for that, which is why it made news. And then some New York City public defenders are threatening to sue because they're concerned about their safety and being forced to go to all these court hearings where there's insufficient PPE and other safety standards in place. So the problem is that these people are entitled to this speedy trial, and the lawyers are saying, "Hey, you can't. I'm not going to put my life at risk like this if we can avoid it." So,
yeah, that's what I was saying. So, Victor, so that all of that is true, except that they're not allowing people to go to Rikers, for instance, to go talk to their clients. So they have to do it in these more public ways now to make it happen. And so I think they might have actually filed suit on Tuesday of this week, unless that was just a threat to sue. I thought they went ahead and filed in New York to slow down the opening of the courts because they still don't have access to a lot of the defense lawyers don't have access to their clients.
I don't know. I still don't understand why they can't just do a direct video hookup from the jail to the lawyer and have them consult privately in that way. But I don't know.
Right. Someone harking back to previous observations. So Camilla Lopez in the chat says, heard a small claims appeal case today where an attorney thought he was on mute and was screaming at the client for testifying incorrectly. Also heard an inmate calling in from San Quentin, which was pretty cool.
Yeah.
Mute hits again.
All right, we should move on just to make sure we can get around. Victoria, you wanted to talk about something from the other side of the pond, right?
Yes, where Caroline is located. Well, I think this was actually in Luxembourg, which I forget which country that's in, but over in the Europe, in the European Union, they invalidated the Privacy Shield, which is a mechanism that companies use when they want to transfer EU citizens' personal data to the U.S. And the CJEU, they said that is invalid because in the United States we don't have procedures that allow us to, that allow remedies for over surveillance or surveillance by U.S. law enforcement. And it was interesting, like data transfers won't end because of this. A lot of lawyers that I spoke to said they're going to, a lot of companies are going to add standard contractual clauses into their policies. But that doesn't just mean you add something new to your contract. They said this, the decision from yesterday really emphasizes that companies need to really analyze what type of data that they are collecting and transferring over to the U.S. And if it's very sensitive data that is more likely for U.S. law enforcement to ask for access for during investigations, then companies need to put in extra safeguards for that data. And that may include just kind of like more notifications for clients when law enforcement reaches out to them to ask for access to their data, or just encryption. So it's a little bit harder so it is harder for U.S. law enforcement to access their data, but I think it'll be something interesting. There most likely will be another part 2 to the Privacy Shield, because the Privacy Shield, its predecessor was the Safe Harbor program, which the CJEU also invalidated a couple of years ago. And then Privacy Shield, I believe, was the predecessor to that. But it'll be interesting to see kind of how companies continue, if they even want to continue transferring EU citizens' personal data over to the United States, or they kind of decide it's not worth it and maybe host it somewhere else in the world.
Yeah, but this is, I think, probably, I haven't got an awful lot to add, to be honest. So this is probably this was a huge story this week. And the Privacy Shield was a long time coming. And it was only really recently put in place. So it's been overturned, quite, it's a huge inconvenience for companies who are trying to manage their transfer of data. So I think they obviously now need to look at the position. The only thing that I would say that I've heard is that because of the flux, and this is a long-running matter, that actually that they haven't relied, that there's been so much uncertainty that they haven't necessarily just relied on the Privacy Shield, that they sort of companies may, I was reading something from Deborah Voice, so companies may want to start identifying for which jurisdictions they rely on standard contractual clauses for cross-border transfers, whether they have local laws that could ultimately render reliance on SCCs invalid. There's so many considerations that it's a big shock decision basically this week. People didn't see it coming.
Huh. Anybody else have thoughts or comments on that?
I mean, my only thought is just Max Schrems as an individual, the one who brought not only this case, but the Safe Harbor as well. His fight against Facebook has now had major implications. So he's definitely somebody probably to continue to watch as he brings up lawsuits, because what he's doing, especially, the case was first in the Irish High Court, but then went to the CJEU. It seems to have major implications across the globe for technology and where data is going to be stored. So it's one of those people probably to watch. And for us as journalists, honestly, when something is happening, he's definitely going to be on my radar moving forward.
Yeah, I thought one of the best takes on it was from TechDirt, who had they said, look, a lot of people are going to view this as if it's a decision against the internet companies. And to some extent, that's true. But the real issue is U.S. surveillance of that data. And that what this should set up, if we lived in a sane world, is now the incentives are entirely upon those companies to start pressuring the government to have some wholesale change so that they can get back on the EU's good side on this sort of thing. But who knows?
The lawyers I spoke to, I asked them, like, oh, do you think there'll still be this will finally push U.S. Regulators to say, okay, we're going to have a national data privacy law, at least on how the law enforcement uses data and collects data. And they said, no, like this will be something that goes towards it, but kind of like, especially now dealing with the pandemic and the political atmosphere right now and it being an election year, they don't see that being the main push. But they did, some of them did note, what was it, earlier this month, Boston, I believe they banned the use of facial recognition software by its law enforcement. That kind of adds on to the cities in the country that are doing that. So there is this discussion, but is it yet enough where the U.S. is going to say, we're going to have a law actually saying like, okay, this is what we're going to do. These are the procedures. This is the process of at least the government collecting this type of data. But from the lawyers I spoke to, they said, not right now. It won't happen.
Yeah, there's also a state bill here in Massachusetts that would also very closely regulate police use of biometric data. We'll see where that goes. But
yeah, I mean, I guess politically, positing the argument that we should be more like Europe probably wouldn't go very far.
Yeah, and they were definitely talking about, one lawyer I spoke to, he said in Europe, because of kind of like their history with communism and everything, they're more worried about government surveillance. And for us, it's more about protection, consumer protection. But he even noted, like with the CCPA, everyone thought that would be kind of like the thing that motivated the United States, the federal government, to say, okay, we need to actually put something on the books about this, but it wasn't. And this decision also probably won't be that push to say, like, okay, we need to actually put something on national law on books.
Yeah. All right. What else we got this week? Joe, I know there's bar exam news. And
yeah. So bar exam, I am all bar exam all the time right now. For those who are just in the tech world and might not have been following this, this whole test that we do for dumb reasons in this country, all over the country, we have a pandemic. It's a disease. You might have heard of it. And it's one of those things that's really bad if you're in an enclosed space with a bunch of people you don't know really close. And that's exactly what bar exams are. And so a lot of states have decided not to have bar exams in July. Some of them even realize it's not going to happen in September. Other states have decided to go forward with it to their peril. But we did get one big development over the week. Yesterday is last night we heard that California is going to go to an online exam to keep their people from having to come into a convention center to take it, which is very exciting in that that's a positive step. That said, it does open another can of worms, which is there was a survey taken before this decision where I believe at least a plurality, if not a straight majority, of the potential applicants said they didn't know as though they could have stable internet for 2 straight days to take the exam on. Internet is spotty in this country for a lot of reasons that mostly deal with cable companies and deregulation. But putting all that aside, we have bad internet in this country. And so a lot of folks didn't think they'd be able to do that. There's a lot of concern about locations where people will be won't get disturbed. And then there's proctoring problems. You can't really get people to proctor 8 million of these exams at once. And so the argument is to use algorithms, our old friend from earlier, to determine if somebody's doing something that looks suspicious enough to investigate as possible cheating. A lot of people are concerned about implicit bias on that front for, good reasons based on, everything about algorithms. So these concerns are still out there, and now they have more time to settle them, but that's where we are. On the other hand, at least they've realized they can't force people to do it in person. So we'll take that win and then move on to criticizing the stopgap solution.
Yeah. Did I also read that California is lowering the standards for passing the bar on a permanent basis, not even just...
Yes.
Why?
And this has been a long time coming. A couple of years ago, all the deans of all the law schools had a study that they brought to the California Supreme Court that basically said these cut scores need to be cut permanently down. They actually didn't cut it yesterday as far down as the deans recommended. But this is kind of the problem with California. Folks, even some of my colleagues flippantly say, "Oh, well, you're just making California's bar easier for bad people to become lawyers." But that's not really what's happening. The cut score that these people maintain out there is absurd. Like, a lot of the people that would fail the California exam would pass New York easily. And obviously New York is a more important bar. And so this doesn't make any sense. And it's just there because they don't use this to protect the public. They, in California, are using it as a guild mechanism to protect the existing population of lawyers. And it's a problem. And the report suggested it was a problem for diversity initiatives, in that a lot of the people who would pass under a more sane cut score happen to be more minority candidates, fell into that window than not. And they also found that there's a huge access to justice problem in California that is frankly the cumulative effect of not having a bunch of lawyers over the years because they get cut off by this cut score. So they are going to use this opportunity to make that reform, which is nice.
Yeah. As I'm sure we've discussed on this program before, as if the bar exam is any real evaluation of someone's competency to be a lawyer. It's such a ludicrous
I passed
process
it.
to begin with. Yeah.
I forgot like 90%. I forgot like 90% of the stuff on the bar exam the minute my pencil hit the table.
Exactly.
But yeah,
Right. And you only learned to take the bar exam. It had nothing to do with anything.
It in decades. Yeah, yeah. It's but I do think that there is kind of the mentality for a lot of lawyers who took it and passed. But they're like, well, if I had to do it, why can't these young whippersnappers do that too?
Right.
And
Teasing ritual.
Right. Yeah. And they had to walk to school barefoot in the snow too.
Right.
And they were lucky.
Yeah. Anyway. Nikki, did you have anything this week? I don't think I saw an email from you.
I did. And it was essentially a meme that's been passed around Facebook come to life. So it made me laugh. There's a meme that, the people that are think you should wear masks are posting, which is, did you hear that the government wants to, they're constantly monitoring you, and if you wear the masks, facial recognition won't work. I don't know if you've seen it, but it's a little more artful than that, but that's the essence of the meme. And then it was just, there was a couple different stories that came out that there were some law enforcement documents that were obtained. I can't remember the mechanism through which they were obtained or for what reason, where DHS was had memos that were expressing concern that all the face masks were preventing them from using facial recognition software to get criminals. So essentially this keeping everybody safe from this pandemic is preventing them from prosecuting people, which I just thought was ridiculous. And that, their primary thing was that there were possible violent people that were going to take advantage of the fact that you can wear face masks and then commit more crimes. But the whole thing's stupid because, all right, fine. Why don't you just go back to investigating and prosecuting people the way you used to before facial recognition? It's not like you still can't prosecute criminals. And second of all, they were going to wear masks anyway. They're not stupid. That's why people wear hoods and do all these other things when they commit crimes. So it just made me laugh that this is not laugh. It's where are our priorities? I mean, come on, folks. Like there's a pandemic, so for a little while, you can't get facial recognition to work for the white men. It doesn't work for anyone else. So come on, find another way to prosecute.
We talked about this early on a few weeks ago because it's a big push in the demonstrator community too, that because law enforcement use crowd images and on social media. So if you wear your mask, you trip up a lot of those facial recognition and identification methods. But that didn't stop the police from tracking down the woman who wore a shirt you could only buy on Etsy. So
right, yeah. How long ago was it wasn't all that long ago when we were talking about the demonstrators in Hong Kong wearing masks, and now everybody's wearing it.
Are you going to mention Ross, Bob? The decision on Monday. I would have mentioned it, but it's kind of nicking your story.
The Ross?
Yeah.
Well, I was going to mention Ross. So the two things that jumped out to me, one was Ross responding to the Thomson Reuters lawsuit, which was interesting. If I'm sure a lot of people in this audience would know about this, but Thomson Reuters had sued Ross, claiming basically that it had hired this third-party company to steal a bunch of Westlaw content in order to help kind of build up its own legal research database. And Ross filed its initial response this week was a motion to dismiss. Interesting because they kind of called into question, Thomson Reuters claims of copyright in its key number system and in its head notes. And, I think everybody understands that you can't copyright primary case law. But I think that there has been, I think a lot of people have kind of implicitly accepted this idea that Thomson Reuters can copyright its key numbering at least and its head notes. And this lawsuit, this motion to dismiss, basically says that all these head notes are a bunch of copy and paste out of the decisions, and there's no originality or creativity involved in them. And that the head notes that the key numbering is really just a sequential numbering using classic legal organization formula and there's nothing original about that. So it'll be interesting to see where that goes. I also thought it was interesting. I hadn't noticed this when I did the story on Monday, but as I mentioned earlier, this was the week that the American Association of Law Libraries had their annual meeting, and Ross had earlier pushed for an extension of time to file its initial response until Monday. And so you might wonder whether they, for the PR folks in the audience here, whether they had, intentionally thought about making sure that they could file their response on the day that kicked off the AALL convention, and get the attention of that audience. But
it's interesting. TR's reaction is interesting, isn't it? When they've come back and said that actually that nowhere has Ross denied that their key thing about their argument is that Ross accessed so that they weren't allowed, because they're a competitor, they weren't allowed to access the data full stop. And Thomson Reuters' response has been nowhere do they deny that they've accessed kind of effectively, illegally or against all TR's terms, the data in the first place. So they've immediately come back swinging, haven't they? Which has been quite interesting, as we observed before about the cases. So quite often it's very hard to get information other than what you can pick up, in public filings. It's very difficult to get people to comment, but in this case, they're very much, there's a sort of like war by media, because as we both reported last time, Ross came out swinging after the last filing, and then the TR have done exactly the same this time, come very, firmly again, saying that that nowhere does Ross deny that it surreptitiously stole content from West, which is quite fascinating.
Yeah, and they did though. I mean, they denied that they stole the head notes. It is funny how they kind of phrased it in their pleadings, but they denied that they stole the head notes or the key numbering, which are, if you read West's original complaint, that's really the only thing that they're claiming was copyrighted anyway. So to the extent there's a legal claim that Thomson Reuters has, is only with respect to the head notes and the key numbers. Although Thomson Reuters is also claiming, tortious interference with contractual relations by virtue of having gotten this company legalese to, the allegation is they got this company legalese to download all this stuff and pass it on to Ross. As I think we've talked about this before on the show, but the Thomson Reuters had settled its lawsuit, had already sued legalese, and had settled that lawsuit within days of turning around and suing Ross. So you have to think Thomson's got something up its sleeve there in terms of the discovery it conducted in that prior litigation. And I think it'll be interesting to see how that plays out.
Their point, I think it's interesting, their point about, if to take your point about, that a lot of this data is public, why then did they need to, when they could get if all they needed was the public data, then why then did they need to access the data through legalese? It's an interesting point. It's an interesting point.
Yeah. Well, they had their own subscription and got booted off of there. And I think the argument again that Thomson Reuters is, some people that I've heard from some people at Thomson Reuters and others, is that the reason they wanted the key numbering system is not to replicate it, but to use it to help train their AI. And I have no reason to know that. That's just an allegation, but certainly there is some benefit to be obtained in training, in having access to that to train the AI.
Oh yeah, garbage in, garbage out. All the programmers say that you need the data for the AI to learn. And if it doesn't, and also just to provide you actionable information, and that's what Lexis and Thomson Reuters have, is tons of data. That's their advantage in the marketplace, I think, when it comes to AI.
Yeah.
Really quickly, I had a question before you mentioned AAL. I saw Kevin posted on Twitter that Tech Show is virtual, but I didn't see that anywhere else. Has anyone heard that? Maybe a Tech Show is going to be virtual?
So what happened? So the weird thing is that the tweet itself still says it's going to be in Chicago. But then when you click on the thing to be a presenter or to propose a presentation or whatnot, it says Tech Show will be virtual. So, I mean, so I don't. I mean, we were still trying to figure out what was going on. We didn't get a straight answer from anybody, and so
Tom
think,
Miles says Tech
Yeah.
Show is definitely virtual.
Definitely
Yeah.
virtual.
Anybody knows is
Okay.
Tom
I think
Miles.
Tom would know.
It's definitely-
Twice chair of Tech Show. So
I was just curious because I was wondering what was going to happen with that because that's a little further out than others. So, all right,
yeah.
that caught my eye.
Yeah, no one told me. I do the startup Ellie thing on the opening night, so I don't know whether Tom, we doing that? We'll find out. Yeah, the other thing I wanted to mention that I thought was a really interesting story this week was the news from Deloitte that had launched this legal business services practice in the U.S. To folks over in the UK, this is probably not such big news, but I think in the United States, a lot of legal professionals tend to overlook the fact that the Big Four are major providers of legal services around the world, and what's kept them out of it here is both our legal regulatory structure and some of the financial regulatory structure as well. But this is, I think this is big news. They're getting into providing a managed services business. Yesterday I interviewed the guy who's going to be heading it up for my Law Next podcast. I think that's going to be up on Monday. I kind of tried to prod him on, what happens if there is regulatory change? What happens if California or Utah or whatever kind of loosen the rules a little bit? Is this a stepping stone toward Deloitte doing more direct law practice? And he, of course, said, "Oh no, we're a regulated industry. We don't think about that at all. We have no interest in thinking about that." But I don't know. I think this is significant, and the managed services area is just so huge. I mean, there was just also news this week that Ed Sohn, who used to be with Pangea 3 and then went to EY Law and now jumped this week to Factor to work with them. That's just a major area to be watching and following. There'll be a lot of interesting stuff happening there.
Yeah. What I thought was super interesting about it too is who Deloitte hired for that, because they were basically cherry picking people from pre-existing ALSPs.
Yeah.
Like I pulled it up here. The guy who you may have talked to, I believe, came from Integrion.
Yeah, Mark Ross. Yeah.
Mark Ross.
Yep. They got Louis Christian from Elevate.
Yeah.
Recently, obviously across the pond, they got Emily Fogus from Luminance. So they're getting all of these people and kind of conglomerating them into one place because they're Deloitte. They can pay that. So that's might be the strategy for them moving forward, is just kind of picking off top talent as they can.
Yeah, and Mark said he was he started with them in January, but he said he was very deliberately hired, for the purpose of starting this business service here in the U.S. So, Victor, I don't think we've gotten you. Did you have anything else? Anything you want to talk about this week?
No, I think I didn't get a chance to propose anything, so sorry about that.
It's not too late.
I guess
I'm sorry. Go ahead.
Yeah.
No, go ahead.
Oh,
Well, I was just going to ask, because of the Supreme Court decision with Georgia cases not being copyrightable, I was listening to a webinar and really started to think about, well, if those aren't copyrightable and they need a formal case, and the states that don't already do that on their own are going to have to, can everybody have access? Do we have a case with Ross and Thomson Reuters if all states have to be public and any startup can have access to all the case law? I'm just throwing that out there.
I think that case would mean that any work product created by a third party, either West or Lexis, for a state that is published in their official reporter is not copyrightable. But anything they're doing on their own, I think their argument would still win.
So one of the points that Ed Walters made was that I think California has a copyright notice on their cases, and he doesn't think that's enforceable. So states think they have it, and organizations think they can't use it, but this case seems to say nope. If it's the formal official state record, you can use it.
Well, the Supreme Court case it was a unique situation because it dealt with regulations, the annotated code, rather, not the regulations, the annotated code. And so they were claiming that because there were these annotations done to the code, that the annotations made it copyrightable. But the court was saying that because this is the official code and you can't copyright the official code, and because you, the state of Georgia, supervised the creation of the annotations, then you can't copyright them. If Lexis was doing the annotations as a standalone thing somewhere, they could certainly copyright that.
And
But-
it was set up that way.
Yeah.
That was how it was so dumb. So it was set up this way because Georgia wanted Lexis to do it for them, but Georgia refused to pay. So Lexis said, "Fine, we'll." I'm putting this shorter. I'm sure like these conversations were more less colloquial, but Lexis was like, "Fine, but if we do that, then we'll hold then you say we have a copyright in it, and then we can be the only ones who publish it, and then we can get the money that way rather than you paying us on the front end." And Georgia said, fine. And so that's how it ended up, that there was this claim that they had copyright over what was there. But the Supreme Court's position was, no, you don't get to copyright your official state documents, even if you farmed it out. Yeah.
So I thought the Chief Justice was very clear. If it's a public record, that includes court cases.
Yeah,
which we're talking about with Ross and Thomson Reuters. When you start to view that as this is very clear and sweeping beyond Georgia, that if this is your formal public record, then and your case law, and you're serving the public interest, then the people own the copyright, not the state.
Yeah, but that's the difference with the Thomson Reuters. That's the difference with the Thomson Reuters case. They're not saying that they own the copyright in the cases. Thomson Reuters is not saying that. They're saying what they own is the enhancements the editorial enhancements that they've added in the nature of the head notes, which they have lawyers sitting there writing, that people on their staff writing, the editors, and the key number system, which is something that they have created.
No, I get the argument. I'm just taking it a step further with, once this is all open, and algorithms are developed through the state, then do you need either of these companies, or what other competitor is going to come up with access to all this information and serve it in an easier, more affordable way?
Yeah.
Well, I think head notes make a big difference when I'm doing legal research.
But Ed Walters for years has said exactly that. He said we don't think that the value that we offer is in providing access to the cases. It's the simplicity that we add to it, or the user interface that we add to it, or the other enhancements that we add to it. That's what makes Fastcase valuable. Anybody can put cases up online right now, and although there's still a question about where a lot of these services actually get their cases, they're all very secretive because, most of them have cases that go quite a bit back in time. And the rumor is that almost all of them all come originally from this same database that was stolen from Thomson Reuters, stolen from Westlaw back in the day, and that has been added onto and built on over the years. There's apparently some secretive place you can go online and download. The dark web, and basically, it's like child porn or old court cases. You can download these things somewhere in the dark web. But
really boring. That's the really boring corner of the dark web with all the cases.
right. It's like Fastcase still sells. A lot of the services buy their case updates from Fastcase. That's a big part of the way that Fastcase makes its money too. So.
Yeah, and actually now I'll have to go and read the complaint or the motion papers in that Ross Thomson Reuters matter, because whenever I talk to anybody from either Westlaw or from Lexis, they made it seem like, oh, these head notes are so beautifully crafted by these experts who spend so much time and so much energy on it, and that's why they have to be protected and whatnot. But if they're just copying and pasting stuff out of out of various parts of the case, then I guess that would kind of cut against that, at least that argument that these are works of art that need to be protected.
Yeah, we'll see. There's still the question of whether Ross keeps saying this is just an attempt by Thomson Reuters to squelch this budding competitor, and
it's a good word.
But And as somebody, I think Joe, I think you saw that tweet, but when earlier this week when I had on my headline something about, I used the image of David versus Goliath, and somebody said I'm not quite sure that that's a fair analogy because Ross has a lot of big money and big name backers behind them as well. But I think the analogy still holds true because I'd much rather have Thomson Reuters banking account than Ross's, I think.
It's still apt because there are some biblical scholars that question whether or not David was actually small and undermanned in that particular, so maybe it is. Maybe it does work.
Yeah.
We did it all.
All right. Anything else? TGIF?
For next week, we've run out of time anyway, but for next week, it'd be interesting to look at, so obviously the financial results are coming in. It'd be interesting to see, that's obviously not legal tech, but it'd be interesting to see what happens there. And also in the UK, the furlough scheme is coming up. So we're expecting a whole raft of redundancies, whether that's sort of particularly relevant to our legal tech world. But I know of quite a few people with legal tech that are furloughed. So it'd be interesting to see when the end of that, out in the UK, when the end of that program comes up, what the position is. But that's probably not a conversation for another time. There's been some interesting stories about that this week in the mainstream legal media.
Sounds good. We'll keep an eye out. All right. Well, thanks to everybody. I, for one, am very glad it's Friday this week, and I hope you all have a great weekend and see you all back here next week.